at allpointstv.com, and we are glad to see you out there. And we know we're going to have an exciting program. If not, don't tell us about it because we think it's going to be exciting, and we don't want anybody to come in pouring water on our parade. I want to say that we'll be picking some of the discussion up about, I think, the fifth program that we're going to be doing. We're going to do a follow up on the Marbury versus Madison case because it's really that case is really the most important case that has been brought before the Supreme Court, and I'm gonna broach the topic today as one of our topics, but we'll go into more detail. Hopefully, we'll do that. Let's see here, maybe in about 5 weeks as we look at our calendar, what we're going to be talking about during the course of the next month or so. Right now, let me start off this program today, though, to talk about this idea that the courts are extending rights to non-citizens, and I want to be clear here about our Constitution and what it requires, and what they're saying about it in terms of what they're claiming that it is a world document. It's not a world document. It's a document for the citizens of the United States. And the history of the country proves that in terms of the 3/5 clause, for example, proves it. And also the Dred Scott case. I was going back over some of that last night as I was looking at, I was going back through this book written by Judge Napolitano called Dred Scott's Revenge. And you can recall the Dred Scott case was Dred Scott claiming he had gone into free states, being a slave. He went into free states and having touched down in states that did not allow slavery and did not recognize it. Since he was in those states where slavery was not to be recognized, then he would be free because he had been in free territories, didn't recognize the institution. He took that case, it started in 1847, appealed to the Supreme Court, and finally in 57, Roger B. Taney, the fifth Supreme Court Chief Justice, the one that succeeded John Marshall, ruled, and this is very important that the court made this ruling. The court ruled that Dred Scott was not a citizen of the United States. And therefore, listen to this part carefully, therefore, there were no rights to be respected under the Constitution of the United States. And that is part of that. Everybody has jumped on Roger B. Taney making that ruling, but that ruling is correct based upon the status of the enslaved population at that point. So that is not outside the orbit of the law. And I don't fault Taney for the ruling. He's gotten a lot of flack because of it, but I don't think Taney is rightfully being accused here, because I guess it's so strange today for persons to actually be interpreting the Constitution, but you don't have the 13th Amendment yet in the Constitution. You don't have the 13th, 14th, and 15th Amendments added to the document. And so what Taney was going by was the way that Blacks were described in the document prior to the amendment of the document, and he was saying here that underneath the Constitution, Blacks were not citizens. And I've heard a lot of speakers. I've been in a lot of classes where the arguments would come up, and they want to argue. They want to put a 21st century argument at that time, a 20th century argument when I was in grad school, put a 20th century argument and export it back into time and have that as the way we look at it during the time period in which it played out there. Now, the time of the court case because the Supreme Court, except in specific cases that are itemized in Article 3, Section 2, Clause 2, if that's not correct, I'm going to be very embarrassed here. But that is, yeah, Article 3, Section 2, Clause 2, where the Constitution explains those cases that would not be appellate cases in front of the Supreme Court, but other than the cases that are mentioned in Article 3, Section 2, Clause 2, all other cases not mentioned would be cases that have to be appealed to the Supreme Court. Now, keep that in mind, because when I get into a discussion about Marbury versus Madison, I'll be touching base upon why that is important, because I don't think these scholars have understood, quite frankly, how egregious that ruling was. That court case, the Marbury versus Madison case, is the most important case that's come before the Supreme Court. And I hope I'll be able to make it clear in our discussion today about why that case is so important. Now, I don't agree with the intention of the case, and I don't agree with the ruling of the case, but I do understand the gravity of it because of what it did and what we now see going on as a result of it. And really, the reason why the court's out of control right now is because of that court case back in 1803. That's why they're taking lodges that are not really entitled by the really the separation of powers. What Marbury does, quite frankly, is that it abrogates the line between the three branches of the government, and that's why I think that ruling is so dangerous. It's the most important ruling that's come before the court, and all these persons today are acting like it that case holds water, and we need to pay attention to it and bow down to it. When that court case is extra constitutional. There's nothing in the Constitution that talks about judicial review, and judicial review should not take precedent over the others that are also able to review the law, because the idea of reviewing the law and construing what the law is something that is germane to each of the three branches of the government, if they all are equally bound to do their part of the law, whether it's to interpret the law, to make the law, or to enforce the law. They all have to have some construal of what the law is. Otherwise, how do you do that job? But understand that the review of the law is akin to, but not necessarily directly related from the. It's akin to, but you can't say that's a proper responsibility of any one of the three branches of government. They all must be involved in reviewing the law in order to do their job, do the job that's assigned to them in the Constitution. And I think the mistake they made in this country is that they have made judicial review something that is substantive to the court and not to the other two branches of government. And that makes it, in fact, unconscionable that would be, in fact, contended by the people in this country, because it's not to be contended if you have, listen to this point very carefully, you cannot even contend that if you have the separation of powers. That's not even arguable, because that is in 1, 2, and 3, the first three articles of the Constitution, the separation of powers. If you say you have judicial review, then you don't have separation of powers. Do you scholars agree with that? You can't have judicial review and then have the separation of powers at the same time. They're not congruent, because the court can take hegemony over the other two branches of government and declare their acts to be within the confines of the Constitution, but they don't have that authority. Then are the powers actually separated? They're not separated. The judicial branch of government has gone into the other two branches of government and has ordered how that should be ordained in other parts of the government that are supposed to be separated from each other and have the clear and distinct role to play in the separation of the powers that were in fact put in place by the framers. And they put it in place, quite frankly, because they found out that the way they had done the power issue, because that was very concerning to them, how power operates in the country. they wanted to make sure that they restrained power. They understood the need to do that, but they had gone about it the wrong way, and they found over time, from 81 to 87, they found out that it can't work that way. It's not they forego the idea of constraining power, but they had learned the hard way through experience. Experience is always the hardest teacher, and they learned through experience you cannot restrain power to the point where it cannot act. You have to restrain it, but you cannot keep power from acting because you have to have power to carry out any responsibilities that are assigned to the three branches of government. But here's what they're going to do something different with that later on. And what they did with in 1803, I think that's an abomination. It's the most important case come before the Supreme Court. But that's an abomination in the Supreme Court. I don't care what the scholars say. That's an abominable ruling by the Supreme Court. But I hope to go into why the court did that, and I want to show the cleverness of John Marshall, because John Marshall, this is Moss speaking. John Marshall, I hear them in these grad classes. There, John Marshall, because of longevity. You know, longevity is one part that builds up the stature of different office holders. Roosevelt, great because he served part of the fourth term, but was elected 4 times, and they got him down there as number 3. As the third greatest president of the United States because of the longevity of Roosevelt. Roosevelt was not a great president. Roosevelt should have been impeached if for no other reason for being a tyrant and refusing to leave office, although being elected, refusing to leave office when everybody else had left, and some had left and wanted to come back and run again, like Theodore Roosevelt had stepped down after serving part of McKinley's term, almost all of McKinley's term, because McKinley was assassinated in 1901, and Theodore Roosevelt, the vice president, stood up in his position and served almost all of his term, and then paying attention to the president set by George Washington, decided not to run for a third term, but changed his mind in 1912 when he ran on the Bull Moose ticket, which caused the election to fall in favor of Woodrow Wilson at that point, because the Republican Party was split between Roosevelt and Taft, and Wilson, the Democrat, came in, and then he comes in with his kingship. That's what I'm going to call it, with his regime, and that was something else that we did talk about at some point. These presidents going out of control and doing things that had no merit and outside of the constitutional guidelines and what they in fact did. I don't know why people call me when they know I'm doing this program at this time of the day. I need to shut this phone off. Sorry about that. As they said, the kids said, "My bad." I need to throw this phone out the window. I'm telling you that those persons that celebrate the judicial review don't need to go back and read about how that was brought about and how Marshall accomplished that, because of the lot. It's very devious and very clever in how he brought it about. I'm going to hopefully be able to put that in context before we get out of here. But let me step back up a little bit and start with these rights. These courts are giving Donald Trump the devil because they're saying that non-citizens have rights and they have due process. Now if you got something like one estimate is that there were 20 million people that crossed this border during the regime, and that's what it was, regime of Joe Biden. Joe Biden was running. This was a regime under Joe Biden, and there was an estimate that 20 million people or thereabouts crossed our border illegally, and many of them in this country. These are cells. Some of these are cells in this country, waiting for the moment. And until we know who those persons are in our country, and we don't even know who's in our country right now, because you can come across that border if you don't have any documents, you don't have any papers saying who you are. We don't know who you are, and and I think I heard Dr. Ben Carson say that if in crossing this border, that border being so porous, and there were no terrorists crossing that border, then that would be what you call terrorism um, negligence. Because if you can cross this border and you're a terrorist and you will harm for the country, why wouldn't you be involved in trying to get in this country illegally if you have illegal aims once you arrive here? And he said that would be what was the words he used? But he was saying that would be like uh, terrorism incompetence. He didn't use the word incompetence, but it's another word he used. But he's pointing to how that would be the terrorists obviously not acting reasonably because you want to do harm, and if people can get in the country and you don't take advantage of that, then that is a terrorist that's not really doing his job, because that's what your intent is, to get into the country and do harm once you get here. So we got terrorists in this country that came across those borders. There's no doubt about that, because that's what terrorists want to do: get in the country and do the harm internally from within, because they cannot bring this country down from the outside. No country is going to send not countries, not governments being stationary. No country is going to send any weapons of war against this country. You can forget that one, because you're a sitting duck, and that's what that's what Ayn Rand is talking about in a book called For the New Intellectuals. She's making that point. Page 47 of her book, when she's talking about there's no power strong enough to bring down this country from outside the country. It cannot be brought down from outside. Because there's too much. You can't bring. You're not going to be able to bring Russia down from the outside. I don't know what they're talking about with Zelensky and so on. There are some countries, unless there's an upheaval inside the country, and they can't stir it up so there's upheaval inside the country, you can't bring those countries down, because they have too much power arrayed against anyone coming from the outside. And that is as true of Russia as it is here. Putin's rating is 80%, for example. And try that with the rating that we have of Biden. Biden was, what, 20 some odd 30% when he left office? Putin not going anywhere. But the point I'm trying to make here is that we have to pay attention to how power operates. And in this regard here, with these internal weapons against us, our own government power is against this country, because whenever you talk about rights and you start giving rights to people who are not citizens of this country, and people who broke into the country and not citizens of the country, but broke into the country, not even here by invitation. We didn't invite these persons to this country. They came in here in spite of our laws, our immigration laws, and we didn't enforce those laws. And they're here now. And the court is trying to say that those persons must have due process. Says who? It's not in the Constitution. This idea that outside, that persons that are not citizens have rights in this country, they don't have rights in this country. There are certain laws we have to follow in terms of, we can't just go around shooting them because they're here. Because we had laws in our books about murder and things of that sort. That's our laws, because those are laws we have to follow. But in terms of this idea that they have to go to court each time we want to deport somebody out of the country. We have to go to court and deport them. That's nonsense. There's nothing in the Constitution anybody in this country can show me where that is in fact the going rate. That's what they say. But outsiders do not have any rights under our Constitution. And if you really just want to look at it generically, at the very top of the document, you have that's sitting at the top of the document, not a part of the document itself, but sits atop the document, is the framers actually saying what they are intended to do before they get underway to do what they're doing in Philadelphia. They're expressing in the preamble to the Constitution. That's the preamble means before the Constitution is even gotten into. They have a preamble. This is what they're trying to do, and it says here, "We the people of the United States." It doesn't say we are the world. We the people of the United States, in order to form a more perfect union, establish justice, not for the world, establish justice here, ensure domestic tranquility. You want harmony inside the country. Provide for the common defense, promote the general welfare, and secure the liberty to ourselves and our posterity, those that we have as we begin to proceed going forward as a nation. So our progenitors, their progenitors, all the way down to the time that we're in right now. That's what the Constitution is speaking to. It's not speaking to the world, and it was never intended that we would have this kind of chaos in our country where we're talking about giving rights to non-citizens. They don't have any rights here. There are no rights. What when they say that they have to go and must be given due process of law, they're making that up. And because they are enforcing it, that should be removal from office. Just like, for example, those persons going down to El Salvador, this is unconscionable behavior. Chris Van Hollen, Senator Chris Van Hollen of Maryland, going to El Salvador. The man has been deported by Trump. They got this gang leader, MS-13 gang leader, out of the country. There are 3 or 4 different members of Congress. Every last one of me to be thrown out of office like yesterday. They're down there pleading with the Salvadorian government to return him back to his home. He's at his home. He's an El Salvadorian citizen. He's not born here. He's not been naturalized here. He doesn't belong in this country. Unless we invited him here, he doesn't belong in this country. He wasn't invited here to the country. And they're down there pleading that they return him, and they're saying return him to his home in Maryland. And they're saying that, and they're accusing Trump, saying Trump is exporting people out of the country who are not citizens of the country. What else should he be doing? Anyone that is here in this country, try to sell that in where Urban is the president over in Hungary. I have a lot of respect for this man because they don't have any immigration in their country because they want Hungary to be for the Hungarian people. They have not made the suicidal mistake they made in the rest of Europe, and they're going to pay for it. Europe is going to pay. And in fact, that handwriting is already on the wall because they were being criticized because you start pointing your finger saying people are myopic and all these terms you throw at them, these slurs you throw at them and make them feel bad about them being a sane country. France, I remember when it was criticized in France when when Fanon was writing his books about a dying colonialism, and France was losing its control of the French Empire, and those persons wanted to come into France. And France was saying at first no to its former colonists that they're breaking away. That it was saying you're not Frenchmen, and so on, and holding the line. And France was uniquely French, but they were learning French in those colonies too. I'll be in a French-speaking country in a few days. I'll be in Senegal. Senegal is a French-speaking country, and they had people who, when the colonial lines were removed, and the dying colonialism had in fact been brought about in the aftermath of World War II. Now the people in the colonies wanted to move into France, and France was being castigated for saying no, when no should have been the answer. You left the colonial land space. Now it's up to them to develop the land in the absence of the French. That's what they were fighting for, and that's what they said the fighting was about. And then when they left, though, they found out that there's a void that was left, and here they're following after the colonialists, and he's left, and they want to leave with him. Explain that contradiction. But France was saying no at first, and France was French, England was English, Spain was Spanish. You just name those countries and so on and so forth. Go look at them now. The handwriting is on the wall because they fell for a farcical notion that you can in fact integrate the world into a country, and you'll have how many in that country? Look at Europe. Europe. Go read the book called America Alone. Yeah, read that book. America Alone. ALONE. America Alone. And you're going to see this world, and there's the U.S. there with the American flag, and there's all these countries that are falling by the wayside because they fell for that nonsense. You can bring the whole world. We're doing it now too, bringing the whole world to you, and somehow you're going to integrate all these different groups, 192 countries in the world. You're going to bring all those countries together, and you're going to integrate them into a society where you have a melting pot of all these different groups. You can blend them into a single whole, because you have in your backdrop this idea of plurals unum.
See, what's missed though, most modern people, for one thing, the Statue of Liberty's got that tablet, it says, you send us that poem from Emma Lazarus. She was a socialist.
Mm-hmm.
Another thing is they missed too, though, the people they originally drew from, the population that came to this country, were from Christianized countries.
Right.
The worldview was vastly different than Islamic, because Islamic doesn't have a they don't have a separation of ecclesial power and secular power. There is none. So there's a big difference right there. And then you're getting people radicalized by colonialism and the degradation they feel and the outrage they feel for that. And so they come over here and they got access to grind. They're not coming here to put the things away behind them. They're not. Because, okay, I'm not going to try to defend colonialism, but every country in the planet at some point in Europe had been colonized by somebody else. Okay?
Yeah.
It's like, and so another thing is, to the very names of European nations weren't given to them by their own selves. They were given to typically by the Romans, like Great Britain and France and England and all those, and Great Britain. All those other countries. Germans don't call themselves Germans. So and also, if it weren't for the Romans, we wouldn't have had the Latin alphabet, the Roman alphabet, And we would have probably we wouldn't have had a system of writing that was consistent enough for actually being usable enough. Okay, because runes didn't work well. I mean, so we had that's what the answer people of the British Isles had. So I mean, we kind of people do benefit off of some of the colonization efforts. Not it's horrible. I mean, it's horrible to be conquered and your culture being shut aside on your own land. Okay, I'm not trying to defend that, but it's a big difference. These people came over here years ago from European nations. They're Christianized. Those other nations aren't.
Yeah, we want to talk about the negative aspects of colonialism. Go and look and see how much of and I'll be in 2 countries in about 4 or 5 days now, and go and look at those countries that benefited from it. That is, say that we want to say that the colonial period was terrible. Yeah, for those that were in the middle of that colonialist scheme, yeah, it was terrible for that group. But in the aftermath of that, they claim that it was terrible for those who are the descendants from it, that are the beneficiaries of what they did in development when they were there. For that, it was not terrible because that pain was pain of that generation. But the pain that they bore put a terrible responsibility upon those that were the progenitors of that, that were their progenitors, because they inherited the benefits without inheriting the pain. The pain was that group, but the benefits, though, accrued to the group that came after them, did not have to undergo that. And therefore, that pain that you have in that situation there puts a tremendous burden and responsibility upon those who are the inheritors to get the benefit of that. They want to claim that this group that benefited are the ones that have that inheritance of that pain. That pain is peculiar to that time period with that group that suffered those consequences at that time. We have to separate that experience. As horrible as it is, nobody's going to ever endorse it as being something that was wonderful. We have to segregate it in terms of the time period and those that were there that went through that storm. That's not the ones that are here today. The ones today, and they don't want to hear this part, but those that are today, they are the beneficiaries of that suffering. Go anywhere in the world and you'll see, go where I'll be in 4 or 5 days, and go and see what I'll be looking at. I won't say what country I'll be in because I don't want to stigmatize my presence there, or also stigmatize the country. But go and look at the conditions that are there. And I've been in some parliamentary meetings in some of these African countries where the talk has been things like this. They'll say this in some of the city council meetings. They'll say to their leaders, they say, you have not fixed the problems that we are here to complain about. And you say you can't fix the problems that we are witnessing and going through. And when the European was here, these problems were not as bad as they are now under your leadership. So can we bring the Europeans back? Those conversations are being held in Africa right now. You'd be surprised at how many times you go in these parliaments and in terms of those kinds of conversations are going on, because they see the condition deteriorated. Because because there were some skills they brought to the task, and those skills were what you have in terms of the development that took place in those countries. Those countries, South Africa right now is a good example of that. Been in South Africa twice. I think I've been there twice, 2 or 3 times. And South Africa is the most developed country in Africa, because the colonialists were there until the 1990s. The rest of the colonialist period, the ending of colonialism, would have been in the 1960s, when there was upheaval of colonialism in Africa at that point, under some of those leaders like Jomo Kenyatta, Kwame Nkrumah, Joshua Nkomo. Who are some of these others? Sekou Touré of Guinea. Just a lot of different. They were the ones that stood up against the colonialists, expecting that in the aftermath of that, Africa was able to go on its own and do great things. That was the ideal, but the ideal did not work out that way. Somebody should read this book written by Charles Adams. It's called In the Course of Human Events. Go look at that. That book is very important to read. It's about Haiti. It's about Haiti, the Haitian revolt of 1790. Go read that book and read about that upheaval where they were so angry about the condition that they had suffered under the French, because Haiti is French speaking. And when they rose up under Dessalines, Boukman, and Biassou, they wanted vengeance. They wanted revenge, and they ended up destroying the whole artisan class. Well, Haiti was the greatest colony that France had. Look at Haiti today.
Look at also China. I mean, Mao, when he came in, wanted to destroy the past, because that's the typical communist thing. Like, they want to unburden us from the past, unfetter us from the past. So he murdered millions of people who practice the arts or the Chinese herbal medicines or whatever. He exterminated them, and I mean, these weren't colonized, but these weren't the effects of colonization. He turned out his own people's history. And that's also done too. I mean, they throw the analogy of throwing the baby out with the bathwater.
That's what it amounts to. And the West does not have the things to apologize for. There's apologizing for, because the West did not just simply go in there and just tear up things one after another. What they did was give a lot of those small units inside these countries were brought together around a common language. They didn't have that prior to that. There were so many different languages. Like in South Africa, there are probably 1,000 different linguistic groups. Every one of those countries, though, is speaking in their parliament in a European language, because to do otherwise, it would in fact create a fraction in the country, because the question would be, which of the indigenous groups in those countries would be the one whose language would be tolerated by the other groups? And the answer is none. Because if you use let's say you're going to be in, let's say you be in South Africa, okay, and so you have there in the Hausa, let's say in Nelson Mandela's group, the Hausa, if you use a Hausa language, then what are you going to do with Buthelezi, the Zulu? What are you going to do with that group? Because the Zulus are a larger group than the Hausa, although the Hausa are the ones that are running South Africa, because the power is in their hands, has been in hands ever since Mandela. What are you going to do if they try to use one of those indigenous languages, and the other indigenous group think that you are now imposing your imperialist culture upon them, and they're going to find some umbrage with that because they want their own culture? Culture is a major problem it's a major issue in Africa. It's not divided racially. It's not divided racially. It's divided ethnically. The groups. I want to use that word they use. I don't mean it in the primitive sense, but they want to talk about tribes. I don't mean, when I say tribes, Africa is very tribal. I don't mean it in terms of people running around in loincloths and savage. I'm not talking about Tarzan here. I'm talking about the people that Africa is very tribal. And that's where the divisions are. And what Europe did, it gave the different tribal groups a common heritage, even in their fighting against the British, the commonality, because they had to forget that they were in Nigeria, forget they were Zulu, not Zulu, Igbo, and Yoruba, and some of these other groups that are there. Those are two largest of the groups, and that you can see that in every one of those countries. The point I was making at the beginning of this talk here was that we have to forego some of the modern ways in which we attack problems and look back in the past and how it should operate there in that time period. I was saying here the Dred Scott case was one example of that. We can look at it through the modern lens and say that this was the way it should have played out because we're looking at it through the lens of the 19th and 20th and 21st centuries. But Dred Scott case was ruled properly, in my estimation, of the way I look at that court case, was ruled properly at the time period, which is 1857 when the Supreme Court made that ruling. That was a correct ruling to make based upon the fact that we have not yet had this war between the states. It really was a war on the states by the federal government over the tariff issue, and that war had not been fought, out of which came the 13th, 14th, and 15th Amendments. But prior to that, blacks were consigned to the role in those countries as less than citizens. And the 3/5 clause picks that up, states that. This idea that blacks are 3/5 of a man, that's made up stuff there. The point is that they were less than citizens, and therefore they had no rights under the Constitution, because in order to have rights in the Constitution, you must be a full-fledged citizen of the country. And they were less than that in terms of they were defined for the purposes of representation and for population and so on and so forth of the states. They defined, they had to have some way in which we're going to count the blacks in the population of those states. And the South wanted to have them counted for the purposes of representation, but did not want them counted as citizenship. And the North wasn't buying that because you're denying them citizenship, but you want to count them as a whole person, and that would give you more representation in the body of the Congress, and that would hurt our power base. And so the North is saying no to that, and they came with an agreement and a compromise agreement, and that was for the purposes of representation in the Congress, because in the House you have members delegated by how many persons are in your state. The House Representative is a House of Representatives, and it's talking about the people who live in those states, those districts, and so on and so forth. And the North was not going to buy. You're going to count them one way in this case, and count another way in another case. We're not going to buy that. We're not going to allow you to pick and choose how you're going to quantify your population. And they came up with an agreement that we're going to count it for both purposes: representation in the Congress. We're going to count them as 3/5 of the population of the free states, free members. So if you have 100,000 slaves, rather than counting them as 100,000 persons in those states, you count them as 60,000 persons. That lowers the population, and so on and so forth. Douglas, by the way, solved this, and he was the one arguing with the great white abolitionist William Lloyd Garrison. That was an argument they had. That was a major fallout that occurred between them when they broke apart. They split on how they saw the Constitution. Garrison saw it as a slavery document, but here's a slave, former slave, Frederick Douglass. Go read his papers. Frederick Douglass saw the Constitution as an anti-slavery document, anti-slavery, because he saw that the document, by restricting the amount of power that were accrued to slave states, by counting the person 3/5 of a whole person for the purposes of counting the population of those states, by limiting the Southern power or the slave power, Douglass saw it clearly as it was, and not very many of these so-called scholars with all these degrees see it the way Douglass saw it. And Douglass never put his foot in the classroom, not one day. Didn't go to school, not one day. Saw it more clearly than these scholars in the colleges are today see it. They still haven't gotten it. The Dred Scott case was ruled properly by the fifth Chief Justice of the Supreme Court, the second longest serving Chief Justice of the Supreme Court. I think he was in there 28 years, wherein Marshall was in there 34 years, 1801 to 1835. This is a very important period of history to study, and I don't think that they spend enough time in looking at what occurred that got this country really so far off balance. But much of it starts off in that time period. Much of what's wrong now in the country that we're facing today in 2025, a lot of that has its antecedent in moments in the 19th century. What happened in, particularly what happened in 1803. I think the most dangerous case, I don't have to think about this one. I said this before in these classes. The most dangerous cases come before the court. I don't even agree with the court on Brown v. Board of Education, but that's another egregious moment in the court case. But and that was made politically. That case was a political case. Has not been that has not been discussed properly about what happened even in that case. But we certainly don't understand what happened in 1803 in the Marbury versus Madison case. We want to look at it through the lens of the present time period. That court case has tremendous problems with it because the undergirding part of the Constitution is that we must have the power in order to keep power from going out of control. We couldn't do it the way we did it under Articles. We cannot, in fact, simply slam power out of the hands of the people running the country. You have to give them some power to act. But how do you do that? Let them act, and they're not, and also make sure that they don't act in ways in which the power gets out of control. How do you do that? And they did a brilliant job of coming up with the way in which you do it. You would, in fact, not have the power arrayed as they did under Articles. Under Articles, you only had one branch of government. You only had one. You had a unicameral government. The Congress was the legislative branch was the only branch of the government at that point. You didn't have a judicial branch. You didn't have an executive branch. And through experiment, they understood that was a problem, particularly when they had the Shays Rebellion in 1786. They saw it was a problem, and they were able to fix it. This is what you do when you go to Congress. You go to fix problems, and once you do that, you go back home. We have to learn. We have to relearn that. They won't go home. They went there. Go look at the number of persons signed their names at the Constitutional Convention at the end. There were 39 names on that signature, that document. Go see how many of them were there when they set the government up. How many of them were there at that point? They were there to do what they did. Went there to Philadelphia to draft the document. They don't mean that they're all going to now be in service beyond their means. Some of them became. We have Monroe was there. He's the fifth president. Madison, the fourth president. Jefferson was not there, by the way. Jefferson was not there at the Constitutional Convention. Some of them became, office holders and all the rest. But how many of them held office on the other side of the convention? That was not what they were there for. They were there to draft the document. They'd been sent there for that particular work, to actually revise the document. But they ended up bringing in, this how ingenious they were. They saw the flaws, and what they decided to do was just bring another document and put it in its place. It was too flawed in order to fix that document. And they decided that it could not be fixed given the problems with it, too many flaws to fix. They've been spending all the time just trying to patch it up. And then even patching it up would not work because the biggest problem they had was they had this unicameral parliament, and they had no executive branch, and so where's the authority going to come from? And they had they worked it out, and they worked it out so to the point where the executive authority, Article 2, will be set up. They had that, and in terms of how that's going to be constructed, decided it's going to be one person. They had the House based upon the population, and then the equanimity of all the states having 2 members in the Senate. And then they had 5 members on the Supreme Court and a Chief Justice. They had put that together. And through trial and error, they were doing what they said they're going to do in the preamble to make it a more perfect union. We, the people, are going to do that. I don't know where they get this idea that we are the world. You can sing about it. They may be singing it differently. I keep arguing with people every day about people telling me the youth are different. I say they may be singing it differently. The youth. Every generation comes up, and every generation is confused. The same confusion of every generation. And people say, well, the children are terrible today, more terrible than they were when you were growing up. No, they weren't. They may be singing it differently. They may be singing it differently. And this idea that we are the world, you can sing about that. That's not what they're doing here. We, the people of the United States of America. These are the ones included in this document. Not we are the world. That's a song. The document is written for the people of the United States. And the people who are not citizens of this country do not have rights under this document. Otherwise, you don't have the 3/5 clause in the document, and you don't have the Taney ruling in 1857 in the Dred Scott case. I don't know what Napolitano is talking about in his book called The Dred Scott Revenge. It's a very good book, but there's no revenge that Dred Scott had. Dred Scott didn't benefit from what occurred after the war came to a close. As they began to wanted to end this problem first and foremost, and in the aftermath of the war, they realized that they cannot go back to slavery, because slavery really was over when the gun started. When that shelling of Fort Sumter occurred, that slavery was over at that point. When the North and South started fighting over had a terror war, slavery had ended. Those slaves were walking off those plantations because they've been looking for an opportunity for the friction to occur so that they can, in fact, get their freedom. And the war wasn't even about them. It was about the South and North fighting. The South is fighting over the tariff, the same thing we're doing with the tariffs right now. And the South was objecting to the fact that tariffs were hitting the southern part of the country disproportionate to the North, and they were paying for the prosperity of the North through the tariff, because the tariff is on your goods being exported. You can't tax exports in this country going out of the country. You can tax imports. You cannot tax exports. And so the South was exporting goods into the other parts of the world, but they were raising a tax on their imports into this country. So the North was benefiting from it because they're getting the taxation, and the South was paying for it because when they export their product, they're taxing the southern the cotton. The southern crop was basically cotton. And so they're paying for the prosperity of the North through that taxation tariff policy, and they object to it. That's what they're fighting over. So I agree with Roger B. Taney. I think Taney makes a very strong argument, because here's a man doing what they should be doing right now. Don't go outside the document. I've had arguments with professors, not arguments, discussions with professors who wanted to argue a 21st century, 20th, it was a 20th century argument at that time in the 1990s. They're arguing that Taney was wrong for the argument he made. Taney is arguing the Constitution. Now, you talk about the document being added with amendments and things of that sort. So today the argument cannot be sustained. But the document has been changed. At that time, the 3/5 clause, the idea that we're going to count the enslaved population for the purposes of representation as 3/5 of the total population, and it would be counted differently if they were citizens. It would count them that way. That's why I know you can't have persons in here now that have due process rights in this country, because if the enslaved population was not given due process rights and they're born on the soil, but were not citizens, how do you have persons that break into the country that weren't born here, even if they were born here, but their parents broke into the country and could not bestow citizenship upon them? How do they have due process rights under the Constitution? It's simply a contradiction of our past, of the history of the country, because the slave population had no rights under the Constitution, because they were not citizens, and they were not and being counted in the population, they were counted as 3/5 of the numbers that they actually were in the population. But because they were not citizens, they were counted less than that, as they should have done in terms of, if you're going to be consistent. If you're not a citizen, you can't count them as a whole person. For population purposes, for your representation in Congress, you count them when it's convenient to count them, but don't give them citizenship. You can't have it both ways. And North was arguing with them about that, and they came with that compromise. This book by Floyd McKissick, called 3/5 of a Man. I've asked them many times in these conferences, show me where that is in that document. Show me where it says that blacks are 3/5 of a man in the Constitution of the United States. You say that's what you say. It's not. That is not what that language is about. In Article 2 of the Constitution, Clause 3 of the Constitution, that is not what that language is about. That language is about trying to figure out how we're going to count the enslaved population in the representation of the southern states. That's the argument. And the North is not going to buy. You're going to count them as a total, a whole person, and then you don't provide them with citizenship. We're not buying that. Don't make them the good guys. It makes them clear about they're not going to allow them to have less power because you're counting them in this case and not counting in that case. For taxation purposes and representation purposes, you don't want to count them as a whole person. When it comes down to I'm sorry, not representation, taxation purposes, you don't want to count them as a whole person. But when it comes down to representation in the Congress, you want to count them as a whole person and not bang one and then not bang the other. They're arguing, that's what the argument is about. And they then decided how they're going to do it. Okay, that's that part of the conversation. The point I want to make about how you have to pay attention to this idea that if you're not a citizen, you don't have any rights in this country. You don't have any rights in this country as a non-citizen. We have to follow our laws in our response to you and so on and so forth. But you don't have any due process rights. What the president should do is what he's doing. Everyone they find that's here illegally, they should deport them. And then when the court comes in and tries to intervene in that, simply say to the court that that is beyond your reach. I'm calling for what Ann Coulter calls for. I think she's right in this. I know she's right in this. Ann Coulter wrote a piece back in January of this year. Brilliant piece. And she's right. She's talking about ignore the court. The court should be ignored. If you're outside of the your if you're going to exercise judicial review, if you're going to exercise judicial review, you have to exercise it within the domain of the judicial branch of government. You cannot exercise judicial review over here in the executive branch of government. You cannot do that. That's what they're doing, and they're doing it because they don't understand the Marbury versus Madison case. I came here to compare Madison versus Marbury in 1803 to what happened with Donald Trump and Hillary Clinton. And they have a lot in common, quite frankly, because both of those elections came out a different way than what was in fact intended or thought it would come out to be. Nobody thought that Adams was going to lose. He had inherited power. They fell into his hands because he's vice president under the great George Washington.
By the way, you got somebody saying that he's saying that they was kind of trying to debate you on this.
Okay.
He said he was saying that it wasn't in the Constitution. Show him where it was in the Constitution that we were 3/5 a person.
Oh, show it to me.
Okay. Yeah, she so yeah, so I was maybe what I'll do is I'll send you the person's Facebook page. And,
Look. Hey, let me tell you something.
Okay, here's
this idea that blacks were 3/5 of a man in the Constitution is a misreading of the document.
Okay, here's what this is person's for. So I've been listening for some time, but I just wanted to add that it was in the Constitution as revised because we were free. We were free the 1776. Yeah. So
look here. Let me tell you something. All of y'all are saying that. Okay, you're saying that. You cannot show that to me in the document. I have it right here. Let me read.
I'll tell you what. I was just gonna say because I had what I'm gonna make sure the person knew that I saw the comment. But
I understand what he's saying because they're all saying it. I'm challenging every scholar in this country that's saying that. This is George Moss. I'm not going to pull rank, but look, you're not talking to a person that's going to tote that water because those persons are toting it, and they all are doing it, and they all are wrong. There is no language in the Constitution that defines blacks as 3/5 of a person. Let me read it to you. I'll read it to you because I want you to read and understand what it says here. In Article 2, that is not true that they're saying here that blacks are 3/5 of a man. And I'm going to read it so we can all be we can finally get clear about what this passage is talking about, because all the scholars are saying what you're saying. Okay. In Article 1, Section 2 of the Constitution. Listen to this very carefully. Article 1, Section 2, Clause 3. Representatives and direct taxes shall be apportioned among the several states, which may be included within the Union according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, excluding Indians not taxed, and 3/5 of all other persons. Representation and direct taxes shall be apportioned based on that formula. Now, where does it say anywhere in there 3/5 of a man? We're talking about representation in Congress, and we're talking about direct taxation. And the way we're going to count them for taxation purposes and for representation purposes, you scholars that write these stupid books that Floyd McKissick wrote back in the day, and I read his book. The book is a misreading of the document. And here it is, a person that never went to school a single day Frederick Douglass is arguing because he read the document. Garrison was arguing was telling him what the document said, but Douglass had learned to read.
So it's the person's asked, so where do they get it from? You know, about the 3/5 of a person. Where do they get that concept?
Because they think that that's describing the person himself as 3/5, 3/5 of a whole person. They don't see the part that at the beginning of that section, Article 1, Section 2, Clause 3, direct representation and direct taxes. We're going to determine how we're going to do that. How we're going to choose the representation in the House. How we're going to choose them. How are we going to make it so that they don't get more representation in Congress in the slave population than they deserve based upon their true population. The South wants to count the population as 1-to-1. The North is objecting to that because if you count them 1-to-1, then make them citizens, and then you can count them 1-to-1. But if they're slaves, you can't count them as 1-to-1. It gives too much power to the South. They're fighting over which part of the country is going to have the most power. Numbers, powers and numbers. In the House of Representatives, you have more people from the South than you have in the North. They're going to determine who the president is going to be. Why? Because all states have 2 senators. The power in terms of the choosing the president through the Electoral College comes out of the numbers that are there. California, for example, has 55 members there. When they go into the Electoral College and elect the president, 55 members there. All of them are citizens. They got 55 votes. You want to give the South more votes than its free population would entail. You don't want to do that if you're in the North. In the South, you want to do that. But for the purposes, and it says in the document there, go read it very carefully and make sure you understand what it's saying here. For the purposes of representation and taxation. Because the slaves are not 3/5 of man, the slaves are property. And they're taxing them for that based upon the property. But purposes of representation and taxation now, because the slaves are property of the slave owners. And they're paying a property tax. And they're saying that the way that they would count them then, for the purposes of representation and taxation, we'll count them as 3/5 for that purpose. This idea that you're going to extrapolate and then say they are 3/5 of a man is absolute nonsense. No scholar who has studied this document or know what they read when they read the document will come up with that stupid understanding of it. Blacks are what 2/5 are you cutting off of the person that you're not going to count? The head, the shoulders, what part of it is not being counted? They're not counting, they're not talking about the person, 3/5 of the person. They're saying 3/5 of the population of that part of the population of the South will be counted. 3/5 of that part of the population. So if you have 100,000 slaves in, let's say, Georgia, you count them as 60,000 persons for the purposes of taxation and representation. That's how you're going to apportion their part of the representation. You're going to count them, you're going to have them counted as 60,000 persons there, which limits the numbers that Georgia would have in the parliament. It makes sure they don't want to have the slave power greater than the power of the free numbers. But they want them counted, and you're not going to be able to convince them to come into a union if you don't count them at all. And so they got to find a way in which you're going to be able to cut the difference. The North is not going to buy and go into an alliance if you don't count them. If you count them a whole person, they're not going to agree to that. And the South is not going to agree if you don't count some part of the population, because that's of the 8 million persons that are in the South at this time. South Carolina, good example. Almost South Carolina is population is half black. They're not going to buy. You're not going to count any of them. So they made an agreement that they're going to count them as 3/5 for both purposes, representation and taxation. And they agreed. That's the agreement they made. But nobody's talking about 3/5 of a man here. These scholars have interpreted that language, have forgotten what it says at the very beginning. The very beginning of it is representation and direct taxes shall be apportioned based on that formula. That's the language. Go and read it again. There's no 3/5 of man in this document. In fact, the document is what Douglas said it was. The document is anti-slavery, as is the Declaration of Independence. We, the people of the United States, in order to form a more perfect union, they're not talking about the slave population. They're talking about the people who are the citizens. And because of that, you can't then come up here in 2025 talking about non-citizens have the right of due process. They don't have the due process rights in this country. That's what Moss is saying. All you other scholars are saying, other than that, come and see me. We have an argument here, because there are no due process rights for non-citizens in this country. And Donald Trump should be able to, should in fact, through the separation of powers, deport all the ones they catch in this country illegally and deport them and not go by way of the court. There's no court to be had here through the separation of powers, because the courts are not the only ones that can construe the law of the United States. Every one of the three branches of government, being co-equal, have to be construers of the law. That's a fact. And this idea that you have here in this country of judicial review, listen very carefully, all you scholars, all of you who are now banding around the idea of judicial review, every one of the three branches of government have to have the power to review the law, because if they don't have a construal of the law, they cannot enforce the law, and they cannot understand what they made when they made the law. It's not something just for the court. It's for all three branches of the government. Otherwise, you don't have a separation of powers. That's Moss speaking, and there's no scholar in the country to come against it. And they better close their mouths. Okay, let me get, you get me very excited here. Let me get out of here. Because John said, if I don't get out of here, John gonna cut his neck off. John's saying, John doing this right now. Cut this. Okay, I'm glad, but I'm glad you called in. We're not mad at anybody. But when you talk about this document here, you're not talking to Mr. John Lightweight here. I just want you to know that. Okay, got to get out of here until next time. Want you to follow your dream. If you don't follow your dream, you never know what's on the other side